I'm Dan Johnson from the Stamford office, and I'm going to discuss how to address common soft issues in estate planning meetings. One of the games that I play, and I don't think this is unique to me, whenever I'm listening to somebody speak, I think to myself, how would I say what they just said? You know, if I'm watching an interview, how would I answer that question? If they're giving a speech, how would I talk about that topic? And I was thinking about this last night. When I started Cummings & Lockwood, I shared an office with another associate who's a terrific guy. And you can't help but listen to other people's phone conversations when you're sitting in the same room. And one time he was going to a probate court hearing to meet a client he had never met before. And so he was trying to describe himself. And it became this tortured thing of, I'm kind of a portly fellow. And so he hangs up and I said, Tim, I don't want to tell you how to describe yourself, but you have a beard and you wear glasses. So don't torture yourself. I think we all do that. You're a professional person, you're sitting in meetings, you're listening to how other talented people, like I'm lucky, I have a lot of talented partners. We work with a lot of talented advisors. You pick up how they describe things, how they describe techniques, how they address issues with clients, and you kind of make it your own over time. And so I thought I've had the luxury of that experience. It might be fun to try to package it a little bit and share with you things that I find myself coming back to in meetings in the hope that you can use it with your clients and maybe in discussing some of the topics, it makes you think about things related to your own planning. So let's start by stipulating this is all an unnatural exercise. There's an organic path from, hey, nice to meet you, I'm looking forward to working with you, to now tell me your deepest, darkest secrets. And I think, ordinarily with a friend, you would expect that to take, months, if not years. And here in an estate planning conference, we're trying to compress it into 60 to 90 minutes. So how do you do that? I thought our partner in Greenwich, a senior partner, Ed Rodenbach, had a nice way of starting meetings where he would say to clients, tell me about your family. Like, let's just talk about what's going on with the kids. What are people up to? Who's married? Who has children? What are the kids up to? What are they doing professionally? Where do they live? And that's a nice way to get people talking about something that candidly they like to talk about. I've never met the most polished person, the most successful person. They light up when they start talking about their children. So it's a great place to start. And as they start talking about the kids, a lot of times organically, the things that we need to hear about surface themselves. And so they'll say, actually, kind of one of my favorites, I hate my son-in-law, I hate my daughter-in-law. Or, we have a substance abuse problem that we're keeping an eye on. There's a health issue that you should have on your radar. I mean, those are important things for us to know. And unfortunately, a lot of times they're said sort of sheepishly in these meetings, like, oh, you probably never hear things like this, or it's embarrassing to admit. And so a couple things I like to say. One is, at this point in my career, I've heard it all, literally. But secondly, the reason I've heard it all is because every single family, if you scratch beneath the surface, something is going on. So I would be suspicious of a client who can get through talking about their family and not raise any issues that they want me to know about. That's the first thing. And then the second thing is, it's important that I know that stuff. The more I know about the clients and their goals and their objectives, the better my advice is going to be. And so what I say to them is, I want you to be comfortable sharing this advice with me. Obviously, this is confidential, but also it's important to the quality of the advice that I can give you, that I know what's going on with your family. A lot of times in these discussions, you will actually surface something that's a real concern. And an interesting thing about doing this for a living and being at my point in life is, I'm at the point of life where the kids are older, you get a sense of what kinds of students they are, what their friends are like. And so you meet a lot of middle-aged people say, I'm happy with where the kids are. We seem like we're on the right path. And then the switch goes off where they say, oh, but they're going to start dating. And now we're going to have outside actors in our family. And what's the consequence of that going to be? And so our partner, Court Delaney in Greenwich, would talk about protecting the family from creditors and predators. And usually what that means is we're talking about what happens in the event of divorce and how we're going to protect the kids. That's the primary concern. And it was a matrimonial lawyer, actually, who said, the question from clients is always, how do you bring this up? Premarital agreement is the best protection against a potential divorce, but it's a very awkward thing to bring up. So how do you do it? And it was a matrimonial lawyer who made the point to me more than 10 years ago, the best way to do it is in a vacuum before the kids start dating, right? So set the expectation that, listen, as part of our estate plan, we want to make sure your inheritance is protected. We've decided as a couple, that not every couple makes this decision, but we've decided that it's important to us that you guys pursue premarital agreements. And so we want to set that expectation now. Great to do it in a vacuum. Very difficult to do it once the kids are dating somebody because it seems like a vote of no confidence in the boyfriend or girlfriend or fiance, right? So now, unfortunately, no surprise, I meet with a lot of couples for the first time where there is a fiance or boyfriend or girlfriend, and the couple says, but we're kind of interested in a premarital agreement. How do we bring it up? And so now you're in the second category, which is a far suboptimal category, which is saying, well, the good news is we're discussing this for the first time. Like, this is an estate planning meeting. You've never met me before. This is a new dynamic for you. I'm bringing up asset protection planning, so blame me. Say, we had a meeting with Dan. We were talking about our estate plan. We're talking about how to protect the assets. It came up that premarital agreements are the best way to protect assets in the event of a failed marriage. That's why we're bringing it up with you. Now, obviously, we've all worked with families where that's not going to work either. They don't want to have the conversation. It doesn't land with the kids. And so that's where people like us will say, okay, now let's start talking about irrevocable discretionary trusts. Here's a trust where we're going to have a third-party trustee. Distributions are completely discretionary. And so it's about as hard as it can be for a creditor to get at that trust. If we have real substantial concerns, other creditor protection issues like a profession that, OBGYN that comes with unusual liability, substance abuse issue, do we start looking at other jurisdictions where it's harder and harder for creditors to get at underlying trust assets? We spend a lot of time in these meetings talking about who should we name for different roles within the estate plan. And just to pause on this picture for a second, so this is a family that looks like they have 5 kids and 4 dogs, which is a lot. We're never going to say that you should name 5 kids as co-executors of an estate. That's too many. We're not going to name minors, of course, as co-executors. But whenever I get to this point in a discussion, I think of 2 separate clients. One who said to me, and this is just about a year ago, but I never heard it before. He said, probably most of us, by the time our kids are about 10, we have an idea of who would be the one I'd be willing to name as my attorney in fact to manage my finances for me. And this is the one who's going to be making healthcare decisions for me if my spouse can't act, and will probably be the one who takes care of me. I thought that was an interesting way to say a lot of parents, it's intuitive who should play these different roles in the estate plan. Another family that I was working with where there were 3 kids who were named as co-executors, and one was kind of sophisticated. He was a consultant. A second brother was also pretty sharp. And then the third sibling was less sharp and kind of slower in the uptake. So as we're going through the estate process, occasionally we would have meetings to talk about a decision that needed to be made. And this one sibling, they would go away to make their decision. And then the one sibling would come back and say, can we have a follow-up meeting to discuss this topic? And no progress had been made. And so we'd have another phone conversation and go through the same topic again. And the brother who was the consultant would go, not in the meeting, but to me afterwards, go bananas, saying, we just paid you to have the same conversation again because my sibling can't follow what's going on in this estate. And I want you, Dan, to think about this every time somebody is thinking about naming 3 executors of an estate. And so I do. I say, be careful if you're going to name 3. That's a lot. It does complicate things administratively. But the main thing is, the skill set you're looking for people who are kind of generally organized, who are diplomatic with their siblings, financially lucid. I would say they're ready to supervise advisors. And then for this particular job, the executor job, I layer in geography too. I'd say, if you have 2 kids, one's in the Northeast, kind of nearby within driving distance, and one is in Ohio, and they're kind of equally able to do this job, I would favor the one who's nearby, because part of being an executor is meeting with your advisors, deciding what's going to happen with the house, deciding what's going to happen with the contents of the house. So let's identify that person first. Who's the best of the kids to be the executor? And now once we've done that, do we want to appoint a helper to help that person? And from my personal experience, my brother and I have acted as executors. It's important we get along. I mean, naming 2 kids who don't get along is a recipe for disaster. I'm sure Charlie would agree with that. But if they do get along and they can help each other, and one will say, I'm going to hold the checkbook, and the other will say, okay, I'll be in charge of the house and the contents of the house. That kind of delegation, ability to delegate between siblings, can be really helpful when you're settling an estate. How does this carry over to trust? I think it's a similar skill set, and so we look for similar qualities, generally organized, financially lucid, diplomatic, ready to supervise people. Usually in the trustee conversation, I'll say we can pretty much take geography off the table, keeping in mind that there are jurisdictions that tax trust based on the residence of the trustee. The one that comes up by far the most often in my practice is California. All the other jurisdictions are west of the Mississippi, so we don't tend to focus on them much on the East Coast. But that is something to just vet when somebody is naming a trustee. California, generally, we start to discourage them because you're paying California state income taxes on top of Connecticut state income taxes. And these other jurisdictions, I think you take a peek if somebody is naming a trustee in a jurisdiction you've never touched before. The job of the trustee is to oversee investment activity. There's an administrative piece, make sure income tax returns get prepared, and then act as the contact for the beneficiaries. And so you want the person who's organized, who has the administrative skill set, but then also somebody who has an existing relationship with the kids. If the kids go to this person to say, I want to buy a house, I want to start a business, I want to pay for a wedding, you want that conversation to be as comfortable as possible. And so in an ideal world, you have a person who is, kind of financially lucid, generally organized, and knows your children really well. If you have all that in one person, that's the ideal trustee. What I say to clients who say, the problem is we have a person who's really organized, would be good at supervising the investment of the money. This person is great with the kids, would not be the right person to supervise the money. Then the question for me is, can you create a team? Can those two work with each other as co-trustees? Whether it's one person or two people, the hardest thing for most clients is to say, okay, now who's the backup? Like you put all this effort into figuring out who's the best trustee. Now, if they can't act, God forbid, for some reason, who's going to be their successor? And occasionally you run into a family that says, we just don't have good internal candidates. Either we have a really strong personality, there's a spendthrift in the family, so there's going to be a lot of saying no, or we have complex assets, and that's where people start to look to professional trustees as an option. There is nothing to throw an estate planning meeting with the young professional couple sideways like talking about guardians, especially if they've never talked about it before. And this slide implies that they kind of see it coming. And my experience is that usually they don't see it coming. And so you're having a conversation with a couple and you get to naming guardians and you say, if this is something you guys have thought about or talked about before, and large generalization, the husband will say, yeah, I thought we were going to name my brother. And the wife will say, your brother? Like, are you kidding me? Like that knucklehead? So now I grew up under two partners who had very distinct approaches under these circumstances. The first one is the one that resonates with me, which is to say, you guys have obviously not discussed this before. Why don't we stick a pin in this topic? When I draft the documents, I'm going to put a blank in there. And now you guys can go have this discussion offline and then come back to me with your conclusion. And we won't sign the documents until you reach conclusion. So that's the way I kind of learned how to handle it. And that's the way I handle it now. The other partner in my office had the more difficult, in my view, approach of saying, well, let's resolve it right now. Like, let's hash it out and come up with a solution. So now the reason this partner did that is because his feeling was better to force them to have the conversation and get this over the finish line, even if they are going to argue about it on the way home and come up with a different conclusion. But like, let's get the conclusion in this moment on paper, and then they can change it if they want to, before we sign the documents. So that partner is probably right. But those 2 to 5 minutes where they're arguing in front of you are so excruciating to me that I just find it unacceptable as an approach. I will say, like when this comes up and it's clear that they are having trouble settling on a guardian or they haven't discussed it before, something I'll usually say is, this is an amendable, like almost everything we're talking about in these conversations, these are amendable decisions. And so if you don't have an obvious A+ answer right now, let's come up with the best answer we can, knowing that this decision is likely to evolve over time. And a very superficial observation is that it does tend to evolve as the kids get older and the family situation changes. Like, again, at the most superficial level, most of the young couples that I meet with name one set of parents as the guardians, like the grandparents as guardians. And then the experience is frequently as the kids get older and things get more complicated and there's activities and there's a lot of physical activity involved with managing the kids' schedules and driving them around. These young professional couples say, now like my parents, they're good for a weekend, but they could never do this on an ongoing basis. And so it's time to sub them out and sub in like a sibling, a friend who lives in the area, somebody who's in a similar financial situation. Then you get to people who are around my age And now the kids are all driving. They're largely self-sufficient. And so what you really want is, if something happened to me and my wife, who could drop their life, basically, and move into our house and see our kids through the remainder of high school, like basically keep their life as similar as possible. And so what you see is people saying, my parents could not have done this when the kids were little and you had to drive them around, but now that they're largely self-sufficient and what they need is somebody to just supervise the operation of the household, the elderly parents sometimes become good candidates again for a relatively short period of time. The only thing that's more morbid than talking about guardians is talking about a family disaster. And this is what we call the situation in our documents where everybody in the family has passed away. None of the beneficiaries in the estate plan have survived. And so it's as morbid as it sounds, which is why on the picture, we just threw up our hands and said, forget about coming up with a picture of a family disaster. I will say a little inside baseball. In the first draft of these slides, the picture was of a family watching their house burn down. And I was showing it to my wife and I said, this is both way too dark to use in an estate planning conference and also not dark enough for what we're actually talking about. But the reason I wanted to mention this is I would say some of the most complex drafting that I've done during my career came out of the family disaster provision, which is a shame because it is such a low probability event. I've been at Cummings & Lockwood for 30 years and I've seen one family disaster, and it happened to be a family where there was one child in the family. So what I say to families is the default in our documents under state law is if everybody predeceases you, the assets are going to go, if you're a single person, parents, then your siblings, then nieces and nephews. If you're married, half to your parents and you're down your family tree, half to your spouse's parents and down his or her family tree. So is there a reason that doesn't resonate with you? And once in a while you'll have somebody say, I hate my brother. Like it's just unacceptable. Even in a family disaster provision, I can't accept that anything would go to my siblings. So then we adjust it. But what I say is let's not get to a place where we're coming up with 100 different beneficiaries. Let's try to keep it simple because this is such a low probability event. By the way, in a similar neighborhood, planning for pets is something that comes up and it can get very complicated, but usually it doesn't have to be very complicated. I have a dog, I'm a dog lover. He doesn't need a lot of money. And so if something happened to him and I name Steven as the person who's going to receive my dog and I give him $50,000, the dog will be well taken care of and Steven will end up with a windfall, I guarantee it. So for dogs and cats, keep it very simple. If you have horses, maybe you think about a trust and that's a different animal because they require a lot more money. So part of this job is protecting yourselves against cocktail party conversation, things that people are going to hear from their friends, techniques that they hear about from their friends. And springing powers of attorney, in my experience, are kind of unique because they're an example of something when you describe it to someone who's never heard of it before, they say, oh yeah, that's exactly what I want. So I'm signing a document that says, in the event that I become incapacitated, this person can sign legal or financial documents for me. Well, that's exactly what a power of attorney is for. When I started Cummings & Lockwood, I'm like, why doesn't everybody use a springing power of attorney? And the answer is because when you actually go to use it, now you have a potential problem on your hands. Because if I give a springing power of attorney to my wife and she goes to use it at the bank, she has to prove that I'm incapacitated, which means realistically, she has to have a letter from a doctor saying that I'm incapacitated and probably a relatively contemporaneous letter showing that I'm incapacitated. So the institutional bias has become to say, unless we can't talk somebody out of it, to say, let's do a durable power of attorney, one that's effective immediately. So we get rid of that issue of having to prove that the person who gave the power is incapacitated, but then let's talk about how we're going to protect it. And so, many of you probably know our normal practice with powers of attorney and healthcare documents is we sign 2 copies, we keep one, and we send the other original to the client. So they have one at home, we have one in our will vault. And for couples who have this concern or clients who have this concern of saying, I want to give this person power of attorney, but I recognize it could be abused, and so I want to be a little bit more cautious about it. So the next level of protection is to say, okay, we won't send you an original. We'll sign 2 copies still, but we'll put both of them in our vault. And then some clients will say, that works reasonably well. We know you, Dan, and so we trust you to, decide whether or not it's appropriate to hand out the power of attorney in the event one of us becomes incapacitated. But what if something happens to you? Then now we're dealing with somebody at Cummings & Lockwood we don't know. And so for that situation, we have it's an escrow letter that some of you have probably seen, laying out the rules of if the person who gave the power becomes incapacitated, here are the circumstances under which you can hand out their power of attorney to the person who has the power. After estate planning documents have been signed, there's the question of, what's the homework? And I always say to clients, one of the most important things is whoever you named as your healthcare agent, first, make sure that they know they're appointed. Spouses usually obviously name each other as healthcare agents. A lot of times they don't tell the kids who's the backup healthcare agent. Sometimes it's all the kids, sometimes it's one of the kids, sometimes it's not any of the kids, because there's somebody else in the family who's a doctor or a nurse. So the first thing is saying, listen, in an emergency, you're my backup healthcare agent. You should know that you have a role to play. That's the first thing. The second thing is, in the event of an emergency and you have to make decisions for me, here's how I feel about end-of-life treatments. It's this morbid, difficult conversation, especially that parents don't want to have with their kids, but it's a critically important conversation to have. The reason I say that is I would say 4 or 5 times a year, just in my office, just in the Stamford office, we see a child who's acting as healthcare agent for a parent who has siblings, didn't know they were going to be acting because the parents never talked to them about it. And now they're making very difficult decisions, being second guessed by the siblings, and they feel like they have no guidance from the parents. And so I say to my clients, you're really doing your kids a service if you tell them how you feel about end-of-life decisions. Just as people have different approaches to end-of-life decisions, they have different feelings about when it's appropriate to make gifts. And what I would say here is, I think as trust and estates lawyers, we feel compelled to say, listen, you have exposure to the estate tax. You have to start thinking about making gifts. Here, based on what I'm seeing, based on your assets, here are techniques that I think are appropriate for you. And every once in a while, when you're having that kind of a conversation, you can see that a client or a couple is getting butterflies. I was taught, and I think it was good advice to say, if this makes you uncomfortable, we shouldn't do it. We should just drop the conversation. Now, this is where the financial advisors can play a critically important role in, if we really think it's a good idea and you can map out the impact of that gift using a Monte Carlo simulation and say to them, listen, if you make this gift, there's no way it's going to have an impact on your future financial well-being. That's the kind of modeling that we can't do. We can say, this is a good technique. I think it's a good match for you, but we can't model out what their financial future is going to look like 20 years from now. So that's where a financial advisor can kind of save the day. And by the way, we can also reverse engineer this. If a couple is coming in for a checkup on their existing estate plan, and we think we might have a conversation about gifting, can the financial advisor, in advance of that conversation, identify assets that could potentially be gifted that would have no impact on the couple's future financial health? Very, very quickly, these last 2 slides, the vacation home, I'm not going to talk about any techniques, but I'm just going to layer in 2 considerations. One is, when the vacation home is going to the next generation, who's in charge? It's easy while mom and dad are in charge because they're setting the schedule. They're making sure the repairs are getting done. They're paying for the repairs. So usually things are getting done on a timely basis. I'm working with 2 families now where the vacation home passed to the next generation. Everybody's an equal owner. There's no money set aside to pay for repairs. And so both families have exactly the same issue, which is mom and dad used to be gatekeepers on scheduling. And now people are showing up unexpectedly when one branch of the family is using the house and nobody likes it, nobody's happy. And they can't get their act together on when repairs should happen and how they're going to be paid for. And so the house, which used to be a source of joy for the family, is now becoming a source of anxiety because its condition is declining. My quick takeaway here, art is its own universe. You're entering a portal to another experience. If you talk to a family that has a serious art collection, there's special insurance for art. There's special ways to help the art travel from one destination to another. Once you start deciding, okay, this is the right time to sell the art, you have to know where the market is, where the potential buyers are. It might be an individual, it might be a gallery, it might be an auction house. And so, my advice to clients who have really any level of art, first you have to know what you have. Like, if you have something, you're not sure if it has value, let's get an appraisal and see if we need to protect it and how we're going to plan for it. If we have something that we know has value, let's think about getting an art advisor into place so that when it's time to dispose of that piece, we have somebody who can guide us through that process. I had one very serious estate where we ended up using one of the auction houses. And if you've never had that experience, everything is negotiable. Whether you're going to pay a seller's fee, what kind of advertising you're going to have, your placement in the auction. And if you didn't know any of that, and most people would not know any of that, you could really get taken advantage of. And so it's great to have an art advisor who does this on a regular basis and can guide you through that process. And my success story on that front was, I had a family who didn't know what they had. Somebody passed away and they had a Russian painting, and the art advisor came in and said, I think there could be something here, and connected it with an auction house. The auction house sent it to an international sale. The estimate was 800,000 to €1 million, and it sold for €5 million. So that's one of my happiest clients I've ever had. I know asking everybody to set aside a morning at a busy time of year is a heavy lift, so I thank you all for doing that for us this morning. I want to wish you happy holidays.